and 4 others.
Okay.
Yes, my lord.
Appearances.
My lord, with the greatest respect.
Yes.
Humbly appears for the plaintiff, my lord.
Yes. You have already adopted your final written address, haven't you?
I will. I have, my lord.
All right. Perhaps pending when Mr. Mbaba feels free to join us, we will proceed with the judgment.
As God pleases.
As God pleases.
The abstract of this case is that all the claimants were the first defendant's employees, employed at various times as junior staff or workers at the first defendant's LLA and Ubima estate facilities. They were so engaged by the first defendant until sometime in 2011, when the first to the fourth defendants supposedly concessioned or privatized the first defendant company to the fifth defendant. These claimants maintained that prior to the said privatization, they were owed various amounts of salaries by the first defendant for over 18 months. The claimants were promised payments of all outstanding salaries in arrears, but this was never done. The claimants' demands remained unheeded too, even after they were all unexpectedly evicted from the first defendant's farm settlements by police and military officers forcefully. Despite several attempts to get the defendants to pay the claimants' entitlements failed, the claimants resorted to this action here for redress of their long-seated grievances with the defendants. The claimants' reliefs against the defendants. The claimants' complaint was originally filed along with other accompanying processes on the 23rd of February 2015. The statement of facts was subsequently amended by a motion on notice dated the 11th of October 2016 and filed on the same day, which was duly granted by this court. Within the claimants' amended statement of facts, they seek the following reliefs. 1, an award of 392,700 naira. Excuse me. 392,700,000 naira as specific damages for arrears of salaries owed the claimants before the privatization of the company and which was not paid. 2, an award of 180 million naira as general damages and compensation for the unlawful termination of the claimants' contracts / employments with the defendants. The claimants opened their case on the 31st of January 2018, calling in the testimonies of 5 witnesses. Eta E. Eta as CW1, Patience Nkwocha as CW2, Kani Iwigbara as CW3, Zion Joseph as CW4, and Polycarp George as CW5. They tendered altogether 7 documents, exhibits C1 to C7. CW1 to CW5 were duly cross-examined by the defendants, and so the claimants closed their case on the 16th of May, 2019. The first and fifth defendants filed a joint memorandum of conditional appearance, statement of defense, and other accompanying processes dated the 2nd of October 2015. The second, third, and fourth defendants, on the other hand, filed a joint memorandum of conditional appearance dated the 20th of April 2015, but filed on the 23rd of April 2015. However, the fifth defendant subsequently filed a separate memorandum of conditional appearance, as well as a statement of defense and accompanying processes dated the 9th of June 2015, but filed on the 10th of June 2015. Consequent upon closing the claimant's case, the fifth defendant opened its defense on the 17th of May 2018, calling DW1, one Edith John Agu, to testify and tender one document, Exhibit D1. DW1 was cross-examined by the claimant's counsel, as well as the second to the fourth defendant's counsel, whereupon the fifth defendant closed his case on the same 17th May 2018. The second, third, fourth defendants opened their own defense on the 4th of March 2022 by calling DW2, one Amadi Chijioke, who did not tender any documents. DW2 was thereafter cross-examined by the claimant's counsel, after which the second, third, and fourth defendants' counsel closed their defense on the same 4th March 2022. This court thereafter adjourned the matter from the 4th of March 2022 to the 2nd of June 2022 to enable the first defendant to open its own defense. However, on the 2nd of June 2022, the first defendant was foreclosed for failing to defend the suit against it, despite ordering the issuance of several hearing dates and notices in that regard. At the close of trial, the claimant's counsel filed his final written submissions and arguments on the 16th of June 2023. The said process was filed out of time, but was regularized by the claimants in virtue of their application dated the 16th of June 2023, which was filed on the same day. None of the defendants' counsel, however, filed any final written arguments and submissions, despite being served with the claimant's brief. I observe that there are proof that service of the claimant's counsel's written submissions and arguments were indeed served on the defendant's counsel. Consequently, they are hereby foreclosed from filing any final submissions or arguments. Upon the order of this court, the parties were issued notices to appear virtually on the 10th of October 2023 to enable the claimant's counsel to adopt his final written arguments and submissions, which was the only process that was filed so far. However, on the said 3rd of October 2023, counsel for the second, third, and fourth defendants applied orally for leave to be allowed to file and serve his brief of arguments on behalf of his clients, having failed to do so timeously due to unforeseen circumstances, and particularly since his office at the Ministry of Justice in Rivers State was gutted by fire sometime in May/June 2023. He lost all his files accordingly, which would have ordinarily enabled him to file within the allotted time given to him. As of the time of his application, he was unable to even file the written submissions and arguments because none of the court's divisional officers in Port Harcourt or Owerri were available from Friday preceding the date of the sitting and the morning of the 3rd of October 2023. He stated that the defendants were committed to even pay the penalty fees of over 170,000 in order for his application to be granted. The claimant's counsel, meanwhile, objected to the application since the defendants were completely out of time to file any final written submissions and arguments, and that no cogent reasons were ever provided long before the claimants had filed theirs. As such, this was another attempt to delay this case. This court, in a terse ruling, refused the application to further adjourn the matter and to grant leave to this set of defendants to file any written final submissions and arguments, simply because there must be an end to litigation, and considering the length of ample time the counsel had to do so, it was definitely unfair and overreaching to the other side to seek a further adjournment just for that purpose. The court, however, granted the applicant's counsel the privilege to present an oral submission on points of law only. Consequently, after successfully adopting the claimant's final written submissions and arguments, counsel for the second, third, and fourth defendants replied by raising a few issues which he believes are germane for the just determination of this suit. The legal issues raised are compressed below as follows. 1, whether the claimants have the local standard to institute and maintain this action against the second, third, and fourth defendants, as they are not employees of the defendants. 2, whether there is a cause of action against these set of defendants, being that the claimants were casual employees of the first defendant only. 3, whether the claimants sued in a representative capacity with a name that is unknown in law, that is, as representatives of field operators of Recent Palm Limited. And fourthly, whether the claimants could be held to have sustained this action against this set of defendants. Learned Counsel cited and relied on the cases of Eregboa versus Onano, I believe, citation supplied, Emeka Akas versus manager and receiver of the estate of Benjamin Gillett, citation supplied, and Idigbe versus Adefarasin, citation supplied for legal inspiration. He finally urged this court to dismiss the claimant's case. In view of the additional task given to further consider these arguments above, this court had to adjourn this matter to today, the 5th of October, 2023, to make this judgment. In the process of preparing my opinion on these arguments, however, I discovered that the second, third, and fourth defendants' counsel had actually raised these same issues preliminary, whereupon this court, then presided by Anwe J., made a ruling that was delivered on the 25th of May, 2016, wherein she had denied all the applications in limine. The ruling is available as a record of this court, which I shall take judicial notice of. So, even though I inherited this matter, which was begun de novo sometime in 2018, the fact remains that the ruling is binding on the parties as well as this court. As such, I make no haste to abide by that previous ruling and adopt the decisions made as made there. Adopt the decisions same as mine. I beg your pardon. And adopt the decisions made as mine in further refusing these set of defendants' counsel's arguments. The said ruling is easily accessible from the court's website from a link which I have provided and added to the judgment, which you shall get shortly after this proceeding. Having therefore exhausted the avenue to raise those legal submissions and arguments which were already determined in this suit since 2016, these sets of defendants are therefore precluded by the principle of res judicata, issue estoppel, to re-raise and re-argue them, save for at the appellate courts. Accordingly, those issues shall not be isolated for determination by this court, except where it becomes necessary to elaborate further on any of those questions, again, in the course of making this court's finding. Please permit me to go straight to the decision part. I'll skip several paragraphs of the judgment. Right, court's decision. I carefully examined all the processes filed in this suit, analyzed the testimonies and the evidence produced, and considered the submissions of the learned counsel for the claimants in line with the issues he raised for determination. This court is convinced that a sole issue suffices for determination by this court, which is whether from the evidence produced before this court, the claimants have established their case against the defendants to be entitled to the reliefs sought in this suit. The trite position of our jurisprudence is well captured by learned counsel for the claimants in his final submissions. Indeed, it is elementary and worthy of consistent reputation that in a civil suit, the onus of proof is statutorily placed on the claimant. This is because the claimant is always the assertor who initiated the suit against the defendant. See Section 131 and 132 of the Evidence Act 2011. Building on this notable legal foundation, underscores the duty of the court to evaluate evidence by placing them on an imaginary scale to determine on which side the pendulum tilts. I beg your pardon. The fact that a defendant produces no evidence whatsoever in defense of a suit does not automatically guarantee the success of the claimant's case, because he still must prove every material facts alleged by him so as to obtain a fair. In Engineer Yakubu Okwanachi versus Digital Toll Company Limited, which is an unreported case, NICN Abuja 2013, delivered on the 16th of March 2015, the Honorable Justice O.A. Shogbola, now retired, emphasized on the necessity of a claimant to prove his case with cogent and credible evidence. In her words, she stated that it is trite law that where evidence of a party remains unchallenged and not contradicted, minimum evidence will suffice. The principle of unchallenged evidence, however, does not create a floodgate for every type of evidence. To qualify for reliefs and reliance from a trial court, such unchallenged evidence must be credible in all circumstances and must be cogent enough to sustain the claim of the claimant. The claimant must prefer evidence of such quality that will sustain the claim as disclosed in his pleadings, even in the absence of the defendants. It follows that the claimants must establish by credible evidence that they are entitled to the relief sought. Until then, the onus propandi will not shift to the defendants. Therefore, it is instructive to note the reliefs being sought by these claimants in this suit, which are: 1, an award of 92,700,000 naira as specific damages for arrears of salaries owed the claimants before the privatization of the company and which was not paid. And 2, an award of 180 million naira as general damages and compensation for unlawful termination of the claimant's contract, stroke employment with the defendants. These courts must now examine the oral evidence adduced by the parties in this suit. CW1, the first claimant, stated on the cross-examination that he was employed by the first defendant since 1983 to 2011/2012, and that he was converted from a casual to a full staff in 1989, and was as well given a letter of conversion. He stated that he was paid daily wages in cash and not monthly salary. That in 2011 and 2012, he was paid 300 naira to 400 naira per day. He further stated that he had no evidence to show he was a full staff or that his employment was terminated in 2012. With respect to the claim of 392 million naira in this suit, he stated that the sum is from the total arrears of salaries owed, damages, and the claimant's pensions. He, however, stated that he did not know his exact personal claims stroke entitlements. CW2, Patience Nkwocha, the 12th claimant in this suit, stated inter alia under cross-examination that she had no employment letter because she left everything behind when they were evicted. She stated that she was paid 5 naira per every bunch of palm harvested at the time she was employed, and that she's entitled to the sum of 3 million naira. It was also her testimony that the said sum is an estimate of what she is allegedly owed. According to CW2, at the time she was made to stop work, her salary was hitherto determined by the quantum of labor she puts in daily. CW3, the fourth claimant, Kanyip stated on the cross-examination that he was employed by the first defendant in 1984 and that he was given a letter of employment. He stated further that he stopped working for the first defendant in 2010, and at that time, he was paid 300 naira per bunch of every harvested palms, and payment was based on the quantum of labor put in. He stated that the sum of 392 million naira being claimed by them all is based on an estimation of what he perceives he is owed by the defendants. CW4, the 21st claimant, Zion Joseph, testified under cross-examination that he was employed in 1986 and he stopped working for the first defendant in 2011. He stated that he was not given a letter of employment. CW4 stated further that he was paid 300 naira per day during his service, and the amount paid each month depending on the number of days of work. CW5 is the second claimant, and on the cross-examination, he stated that he was employed in 1984 by the first defendant, and he worked until 2011. He was issued an employment letter as a casual staff. According to him, payment during the time he worked for the first defendant depended on the amount of work done. He maintained that he was not issued any termination letter, but that they, with other claimant workers inclusive, were chased out of the palm estates by the police. He further stated that he did not know the exact amount he is owed, but that he is owed over 18 months' salary. He testified that he was in the field when security men came and drove them out, and he lost all his belongings as a result. According to him, all the 30 claimants do not have the same entitlements. From the claimants' relief 1, they seek from the court an award of 392,700,000 naira as specific damages for arrears of salaries allegedly owed them by the privatization of the company, which is still unpaid to date. It is deducible that they seek specific damages to the tune of 392 million naira, 392,700,000 naira. It is imperative to emphasize that for specific damages to be awarded, the special damages should easily lend themselves to qualification and assessment and supported by evidence. It then follows that without such strict proof, no such awards can be made by the court. Suffice it to stress that before considering whether specific damages can be awarded to these claimants based on their evidence before this court, the court must determine the nature and extent of the supposed arrears of salaries owed the claimants and what evidence has been placed before the court to determine the alleged debts. The court must not mistake the sum of 392 million naira sought by them to be proven or unchallenged, since it is clear from their testimonies of the claimant's witnesses under cross-examination that the said sum is supposedly an estimated figure of all the claimants' entitlements, which even the defendants have unsuccessfully challenged. Curiously, these claimants have not specifically pleaded or particularized their individual entitlements to the alleged arrears of salaries supposedly owed them by the defendants. Although CW2 mentioned under cross-examination that he is entitled to 3 million naira from the total claims in this suit, it was even more mind-boggling and thought-provoking for the second, third, and fourth defendants specifically that the claimants chose to state that they represent Field Operators Wisdom Palm Limited, even though this court had in 2016 determined that they did not institute this action on behalf of the other workers, not minding how the suit was couched, but for themselves as individual workers. Although a euphemism, but nobody should be made richer or poorer as a result of another's misfortune. This further underscores the need to strictly prove special damages. Again, CW1 stated under cross-examination that they, that is the claimants, were paid daily wages by cash. In addition, CW5 stated under cross-examination that he did not know how much he is owed by the first defendant company, since there is no documentation whatsoever, and that all the 30 claimants have varying sums allegedly owed them by the first defendant. These claimants tendered in evidence exhibits C2, C3A, and B. These are letters from the Field Operators Wisdom Palm Estate Ubima, Owerri Local Government, River State, addressed to the sole administrator, Wisdom Palm Estate Ubima, River State. In exhibit C2, which is dated the 14th of November 2011, the said administrator was requested to remember all the workers in various categories, such as the harvestmen and women, manual and garden collectors, who were accordingly owed by past administrators of the Palm Estates. Exhibits C3A and B, dated the 16th of March 2012, is also another reminder to the same sole administrator about the outstanding entitlements of the former field operators of Wisdom Palm, that is the first defendant. It must be emphasized that the defendants deny receiving these letters and that they put the claimants to the strictest proof of this fact. Meanwhile, CW1 stated under cross-examination that Exhibit C2 was written to the erstwhile sole administrator and the then Commissioner of Agriculture of the state. He stated that the document was served personally by him before his lawyer also did the same. He further stated that he could not remember the name of the then Commissioner of Agriculture whom the letter was served on, and that the receiver of the letter did not officially acknowledge its receipt. From critical perusal of exhibits C2, C3A, and B, I have become quite certain that there is no mark signifying the receipt of those letters by any of the defendants. Another deducible feature is that no monetary sum was specified to be the total entitlements being owed by the makers of those documents. Therefore, estimating what weight to attach to these exhibits, Therefore, estimating what weight to attach to these exhibits, this court firmly believes that those exhibits must be taken with less than a pinch of salt. There is therefore no gainsaying that the death of evidence to substantiate the claimant's claims to relief, one, impugn the credibility of their entitlements to the said sum of 392,700,000 naira with wobbling effects. It is unsafe for this court to rely on mere estimations to grant specific reliefs. Hence, the claim by them for the sum of 392 million naira as specific damages for arrears of salaries owed before the privatization of the first defendant company is substantiated, and same is accordingly denied. Relief 1 is hereby refused and dismissed. As for Relief 2, the claimants seek for an award of 180 million naira as general damages and compensation for the unlawful termination of their contracts / employments. The defendants stated beyond peradventure that these claimants are unknown to them. The first defendant stated under its first paragraph of its statement of defense that the first claimant, as well as all the claimants in this suit, are unknown to the first defendant. Needless to state is that issues were joined on the question whether the claimants were workers or the employees of the first defendant or not. The claimants adduced documentary evidence in a bid to establish the fact that there were various staff or workers of the first defendants, particularly Exhibit C1, the first claimant's Reason Palm Limited identity card, Exhibit C4, house allocation letter of the 12th claimant dated the 2nd of April 2003, Exhibit C5A, house allocation letter of the 4th claimant dated the 29th of September 2004, Exhibit C5B, 4th claimant's Reason Palm Limited identity card, Exhibit C6, house allocation / relocation of the 2nd claimant dated the 6th of October 2003, and lastly, Exhibit C7, house allocation of the 21st claimant dated the 9th of January 2006. These exhibits were duly admitted in evidence without any objections from the defendants. The law is well settled that unchallenged and or undisputed evidence is deemed admitted, and the court can always act upon same. However, although exhibits C1, C4, C5, C6, and C7 suffice as evidence of the 1st, the 12th, the 4th, the 2nd, and the 21st respective claimants' employment statuses in the first defendant company at the material time in question, same evidence cannot be safely stretched to encompass the other claimants' employments without more. The question must be answered whether there are other credible evidence to establish that each of these 30 claimants were all employed by the first defendants. I am constrained. I do not find good evidence to answer this in the affirmative. This court cannot assume that since there are sufficient evidence that 5 out of these 30 claimants are the first defendant's employees, then the rest of them were also workers by extension of the available pieces of the evidence. It is right that where wrongful or unlawful termination of employment is alleged, the onus is on the claimant to place before the court the terms of the contract of employment and the manner in which the terms of or a fraction of it was breached. It follows that in the instant suit, the onus is on the claimants to adduce credible and cogent evidence in proof of their claims that their employments were wrongfully terminated. The claimants are there in paragraphs 15 and 16 of the amended statement of facts as follows. 15, rather than pay the claimants, the defendants used force to chase them out of the farm settlement. 16, the claimants were denied the opportunity to take their belongings on the day they were driven out of the estate. The closest reaction to the claimants' averments that they were forced out of the first defendant's settlement is found in paragraph 9 of the first defendant's statement of defense, where it is stated thus: the first and fifth defendants deny paragraphs 15, 16, 17, and 18 of the statement of facts as they are figment of imagination of the claimants, whereupon they put them to the strictest proof of sin. It must be noted that the first defendant called no evidence whatsoever in this suit, and so it did not afford the claimants any opportunity to cross-examine their witness to determine the questions relating to the claimant's mode of disengagement, particularly pertaining to the issues of forceful eviction. I am inclined to set down the oral evidence of the claimant's witnesses relevant to the issue at hand. 1. CW stated as follows. Question: in your paragraph 34, you mentioned that you were chased away from your accommodation or dwellings by the police and army. You did not sue them here. Answer: yes. 2. The CW5 stated as follows. Question: when did you stop working for the first defendant? Answer: 2011. Question: were you given termination letters? Answer: no. We were chased out by the police. Respecting the issue of forceful eviction, DW1, that is Edith John Agu, stated under cross-examination as follows. Question: fifth defendant took over the Palm settlement after the lease was executed? Answer: yes. Question: there were existing workers when you took over? Answer: no. We employed our workers. Question: by the time you took over the first defendant company, the claimants were occupying apartments / dwellings in the farm settlements? Answer, I am not aware. Question, your company evicted the claimants from their quarters? Answer, I have no idea. Evidence before this court irresistibly suggests that the defendants, most especially the first defendant, are evasive in responding to the claim that the claimants' employments were wrongfully determined. Firstly, aware that none of these claimants ever worked for any of the defendants. Contrarily, this court found that some of the claimants established the fact that they were employees of the first defendant. Again, the defendants deny evicting the claimants from the first defendant's settlements or even terminating their employments. This is not unexpected, at least not when the defendants relentlessly clutch onto the assertion that the first claimants and others were never their employees. However, regarding the alleged use of force by the defendants in ejecting the claimants from the first defendant's farm settlements, the evidence adduced by these claimants do not readily lend themselves to easy discernment. This is so since CW1 stated under cross-examination that his employment was terminated in 2011/2012. CW2 could not recollect when his employment was terminated. CW3's evidence is that he stopped working for the first defendant in 2010. CW4 and CW5 stated that they stopped working for the first defendant in 2011. It is thus deducible that these claimants did not all stop working for the first defendant at the same time. What is more curious is that there are no particulars of the alleged forceful evictions within the claimants' joint statement of facts or in their evidence. The year the evictions even took place is unknown, and it is dangerous to infer, based on assumptions or speculations, that the supposed forceful evictions were the same means for which each of the claimants that was allegedly put out of the employment in the first defendant farms experienced. This is further mystified by the fact that the claimants did not stop working in the first defendant farms at the same time. It must be borne in mind that the claimants' relief too is for an award of general damages predicated on the claim of wrongful termination of employment. It is beyond peradventure that these claimants have not produced any terms of their respective employments which pertains to the agreed mode of determination of their individual employment contracts. The first 12, 4th, 2nd, and 21st claimants who testified as witnesses did not state the terms either. The claimants aver that they were never issued employment letters by the first defendant and that they were promised severally by the administrative department of the first defendant that their appointment letters would be made available to them. Paragraph 17 of the claimant's amended statement of facts. However, CW1 testified under cross-examination by the first defendant's counsel that he was issued an employment letter, although he did not tender it in evidence in this suit. This court actually believes that although they failed to adduce any physical letters of employment before this court, they were indeed casual workers in the first defendant's facilities before the company was privatized and taken over by the fifth defendant in this suit. This stems from their testimonies alluding to the fact that they were paid wages of various sums which they depended on for their livelihoods until the privatization. It must, however, be noted that in virtue of Section 7 of the Labor Act, LFN 2004, it is the duty of the employer of labor to issue a letter of employment not later than 3 months from the commencement of any employment, which shall contain the terms of the employment, including the mode for the determination of such employment. The first defendant remained resolute in his denial that these claimants were not its workers. This court already found otherwise, although it may be difficult to determine how their respective individual employments were terminated in the absence of any evidence in that direction. The defendants are far from proffering any ready answers to this question as well. DW1 stated under cross-examination that the fifth defendant did not absorb the existing employees, stroke workers of the first defendant when it assumed full control and management of the first defendant's concerns, but that the fifth defendant recruited its own fresh workers. So, how were the existing workers of the first defendant company, including some of these claimants, disengaged after the management took management takeover by the fifth defendant. It is well enshrined in the Labor Act that either party to a contract of employment may terminate the contract on the expiration of notice given by him to the other party of his intention to do so. Section 11, sub 1 of the Labor Act. That section provides in subsection 2 that notice, the nature of the notices which shall be given as follows: for 1 day, where the contract continued for a period of 3 months or less; 2, 1 week, where the contract continued for more than 3 months but less than 2 years; 2 weeks, where the contract continued for a period of 2 years but less than 5 years; and 1 month, where the contract has continued for 5 years or more. Now, CW1, CW3, CW4, and CW5 testify that they commenced work in the first defendant company at various dates from 1983, 1984, 1986, 1984 too, respectively. From their evidence before, therefore, they worked for the first defendant for more than 25 years as casual workers. Their evidence, which is that their employment was wrongfully terminated, their employments were wrongfully terminated by the first defendant, was not controverted by the defendants, and it is trite that the court is bound to accept uncontroverted, cogent, and credible evidence. Meanwhile, the provisions of Section 11, sub 2 of the Labor Act imports a mandatory and strict compliance and not a discretionary guideline. The provision commands an obligation upon whoever wishes to terminate an employment relationship between the employer and an employee, except the terms of contracts expressly provides otherwise. The provisions under Section 11, sub 2 of the Labor Act must be complied with. There is no gainsaying that arbitrary and whimsical termination of employments is globally repugnant and also a breach of international labor standards and best practices, which is seriously frowned at by this court. We may see Sahara Energy Resources versus Oyebola. So, insofar as there are no evidence by these defendants to contradict the claims and oral testimonies of the first defendant, that the first defendant wrongfully terminated the employments of some of the claimants, especially the first, second, fourth, 12th, and 21st claimants, including perhaps other field workers who worked for the first defendant prior to 2011, when the fifth defendant assumed full management control of the first defendant company, I hereby find that the claim for wrongful termination against the defendants to be probable, and I so hold. This suit was instituted jointly and or severally against the fifth defendants, to wit, Reason Palm Limited, Ministry of Agriculture, Rivers State, Attorney General of Rivers State, Government of Rivers State, and SIAT Nigerian Limited. The claimants' witnesses testified that the first defendant employed them. However, they stated that they joined the rest of the defendants to this suit because the fifth defendant acquired the first defendant by way of privatization. Again, I wish to reproduce the testimonies of CW1 under cross-examination in this regard as follows. Question: you believe the fifth defendant acquired the first defendant? Answer: yes. Question: that is why you sued the fifth defendant? Answer: yes. Question: you believe the fifth defendant acquired the first defendant's liability and assets? Answer: yes. Question: you believe the arrears owed you should be paid by the fifth defendant? Answer: yes. The rest of the claimant's witnesses testified in the same manner. On the flip side, the fifth defendant tendered Exhibit D1 in evidence. This document is the lease agreement made between the fourth defendant and the first defendant and the fifth defendant. Exhibit D1 is dated the 7th of December 2011, and it must be noted that these claimants are not parties or previous to the said agreement, and so they cannot enforce same. However, Exhibit D1 was tendered in evidence by the fifth defendant for evaluation by this court, and for the ultimate, just, and comprehensive determination of this suit. Therefore, it is imperative to reproduce the recital part of Exhibit D1. The recital part provides as follows. RSG, I believe that will be the Rivers State government, and the shareholders and the board of Reason Palm Limited, herein represented by the RSG, are seeking a qualified investor to take over the entire operations and management of all the assets of RSL, with the intention of creating a strong base for its future growth, provide employment, and in general enhance the state of the economy. SIAT has provided or presented itself as a company with a proven track record of over 20 years in the field of tree crop agriculture, processing and setting up of a downstream facilities in 4 countries of West Africa, and more specifically in Nigeria, and is desirous of acquiring the assets of RSL to fulfill the objectives of RSG mentioned above. A cursory examination of Exhibit D reveals some clauses that I deem salient to the current discourse to reproduce. Clause 6 is titled Liabilities of RSL, and it provides in paragraphs A, C, D, and E as follows. They are outlined there, they're quite lengthy, so you read them. Now, so respecting the current state and the position of the first defendant company, this court is convinced that the tripartite agreement, Exhibit D1, between the first, fourth, and fifth defendants establishes the room for the settlement of claims and liabilities against the first defendant, which makes it appropriate for their joint involvement in this matter. Indeed, it is not out of place to reason that in the course of executing, managing, or implementing the said contract, these claimants' rights were affected as workers. Again, as itinerant workers, their livelihoods depended on working on the palm plantations, and it would be unfortunate for them not to be able to make demands for certain claims simply because they could not all produce their respective letters of employment and or termination, despite the overwhelming evidence that they were indeed under the employment of the first defendants within the material times in this suit. This court is therefore robed with the virus to prevent unfair labor practices and to compensate such victims of such practices, as well as to award general and exemplary damages and or compensations in deserving cases and in accordance with the extant and global principles of the law of employment and labor. You may see section 254C1F of the 1999 Constitution, section 19D of the National Industrial Court Act 2006. In virtue of Article 4 of the ILO Convention on Termination of Employment 1982, number 158, and I quote, "The employment of a worker shall not be terminated unless there is a valid reason for such termination connected with the capacity or conduct of the worker based on the operational requirements of the undertaking establishment or service." This is a shift from the common law position that an employer has the power to terminate an employee with or without reasons, and this court has adopted the principle of unfair labor practice as provided for by the ILO in reaching some of its recent decisions. You may see Bello Ibrahim versus EcoBank, citation supplied, and Sahara Energy Resources versus Ebola, citation supplied. In essence, this court's stance is to ensure to do what is just in every employment or labor case, which may often require the adoption of global best practices in order to reach some such fair decisions. This is one such case where this court must denounce the treatment of the claimants by the defendants as an unfair labor practice. Therefore, on the strength of the foregone, this court is of the firm opinion that the claimant's relief number 2 succeeds. This court hereby awards the sum of 15 million naira only against the first, fourth, and fifth defendants in favor of the claimants as general damages and compensation for the wrongful termination of their respective employments in the first defendant company and for the unfair treatment of the claimants as workers after the takeover of the first defendant company by the fifth defendant. The said sum shall be paid within 30 days of this pronouncement, which shall in default attract 10% interest per annum until fully liquidated. Judgment is hereby entered accordingly.
As court pleases.
Yes. Are the counsel here? Mr. Mbaba. Mr. Ekioku.
Very well, my Lord. My Lord, we are grateful for the well-considered judgment of the court, and we are happy that finally this matter is off the court list of the court. We wish the court all the best.
Thank you. I wish you all the best as well. Mr. Mbaba, if you're listening, you'll get a copy of the judgment immediately after proceedings today. I wish you all the best, and thank you for joining the session. Court clerks, are there any announcements?
No, my lord.
Okay. How are you all doing there?
We are fine, my lord. We are managing, my lord.
How is Owerri?
We are managing everything here, my lord.
All right, it is well.
Yes, my lord.
My regards to your family as well.
Thank you, my lord.
All right, the court will rise.
Court.